Welcome back to the OMB Law Board. I'm Simon Bennett, and today I've got Alex from our body corporate team. Alex, welcome back to the podcast.
Thanks, Simon. Thanks for having me.
No problems. Now, listen, I want to get into this because body corporates and strata have these things called bylaws, and we all hear about it. No parking, no smoking, no pets. You can't do this, you can't do that. No parties late at night, too much noise. And they're governed by things called bylaws. But a body corporate's a toothless tiger, and a bylaw is actually enforceable. Today, we're going to drill down on all of that. And Alex, you work in this space all the time.
Yes, I do. And we do a lot of bylaw enforcement for our body corporate clients. The short answer is no, it's not a toothless tiger, but it can be a bit of a process and a bit of a frustrating process. So it's one that I think it's good for committees to understand properly.
Okay, so if you're interested in bylaws and their enforcement and the enforceability of them, stick with us on this episode as we drill down on those issues. Alex, let's go back to the beginning. What's a bylaw?
Well, in the simplest terms, a bylaw, or the bylaws as a whole, are the rules that govern the body corporate. So you've got typically what you'll talk about as the 3 tiers of government, and some people will call it the 4th tier being your body corporate. You've got kind of this private arrangement where you live in community title, you share areas with other people, and these are the rules that govern those areas and your rights.
I quite often think about the bylaws as protectors. They restrict you, but they also protect the asset or the environment in which you live in this community space.
Yeah, that's right. It's interesting that you use the word restrict because the legislation actually doesn't allow the bylaws to be restrictive. The wording that we typically use is regulatory or regulation. Basically, the difference is you can create rules and processes, but you can't stop people from doing things within reason. So that's our starting point when we talk about bylaws and we talk about whether they're enforceable or not. We look at, okay, is this restrictive or is this regulatory? And does it actually benefit the body corporate and the occupiers?
So let's talk about some of the most common bylaws that cause you issues and problems before we get into their enforcement and the regulatory side of things and how enforceable they are. So what are some of the most common problem bylaws that we see?
Well, I would say parking is a really common one. Parking in visitor spots, parking in the wrong spots in general, parking on the grass, things like that. Noise and nuisance, pretty common. I mean, people have parties, people sort of make noise at night playing games, whatever that might be. Also pets is a common one. But it can be a whole variety of things. I mean, it can be not getting renovation approval. That can be one of the more severe ones that we deal with quite commonly. And the consequences of it, if it's noise, obviously you've got the nuisance being the main consequence. If you've got an unapproved renovation, you might have load-bearing walls being ripped out. That's one that I've had to deal with very recently. And it's important that people follow them. Okay,
so let's say these bylaws are well-grounded. They're created by the community management statement and all of that is passed and they're validly enforceable bylaws. Now you've had a breach. So, for example, load-bearing walls, serious breach. How do you go about enforcing them and how enforceable are they?
Well, as a starting point, we look at contravention notices. So if the body corporate, by the time they get to us, generally they will have tried writing to the person directly. Depending on the urgency of it, they might have just come straight to us. But if that hasn't worked or whatever sort of direct approaches they've attempted haven't worked, then we move to the next stage, which is a contravention notice. So a contravention notice is a statutory notice, which just means that it's provided for under the legislation. The meaning of a contravention notice is essentially to say, here is the bylaw we say you're breaching. Here is the conduct or the reasons why we say you're breaching it. And you either have to cease the breach if it's ongoing, or you can't breach that bylaw again in the future. And the effect of that notice is if they don't comply with it, it's an offence.
Okay, so the body corporate authorises the issuance of the contravention notice.
Yes.
It's served upon the lot owner, I presume.
Yes, it is.
And does it provide a time frame for rectification, for example, in the load-bearing wall space, or are there
Yeah, typically it does. It depends what sort of notice it is. So you've got a future contravention notice, which is for repeated contravention. So
Future
say you've
conduct.
got parties
Yep.
and they're making lots of noise. You say you've breached this and you can't breach it again. And so that has a limit to how long it is enforced for. It doesn't actually last forever. A continuing contravention notice has to give a set time frame within which, so say for example, a common one is people might build a little fence or something out the front of their unit. So it's a townhouse scheme. And we'll say you have to remove this or get approval within X number of days. And if you don't do that, then you're in breach of this contravention notice.
Okay. So we've issued the contravention notice. There's a continuing breach, or the previous breach, for example, the fence scenario, hasn't been rectified, it hasn't been approved, or it hasn't been removed. What's next?
Well, that's where it gets interesting. There are two options, broadly speaking, for the next stage after a contravention notice. The first is probably, I would say, the more common, and maybe not the one that we always encourage, but it's to go through the Commissioner's office. So for the viewers, to give you some context, in Queensland, and this is all talking about Queensland, the process is different in other jurisdictions. In Queensland, we have a Commissioner for Body Corporate and Community Management. We're actually quite unique in that. That Commissioner has lots of powers under the legislation, but essentially they can resolve disputes. What that means is if the Body Corporate wants to file an application with the Commissioner will look at that application and say, okay, is there grounds for us to make a decision on this? If there are, it'll be referred to adjudication, and then an adjudicator will look at the dispute. It can take typically some months. They're a very busy jurisdiction, as you can probably imagine. They will publish orders saying, typically, if there is a bylaw contravention, the orders will be something to the effect that the lot owner can't continue or they have to take certain action to cease the contravention. And if they don't comply with that order, it is also an offence. And when I talk about offences, these are legal offences where you can get fined. The person who enforces that is the body corporate, but the fines are very severe if you don't comply with an adjudicator's order. If you don't comply with the contravention notice, as I said earlier, that's also an offence, but it's a smaller fine. And that actually takes us to our other enforcement option after contravention notices, which is to go to the Magistrates Court, again in Queensland. Basically, you have to go through the Justices Act, which is very old legislation. You get a Justice of the Peace to sign off on a complaint and summons, which is just a very old type of charge where you charge someone, you give them this document that says, this is the offence you've committed, you have to come to court on this date, and you go before a magistrate and they have to plead guilty or not guilty to that offence. So obviously that's quite a significant thing. I mean, most people would find that very confronting. It's a much quicker solution typically because you get a return date within a few weeks, which just means you go before the magistrate within a few weeks rather than waiting months and months for the adjudicator's order. But it really depends on the circumstances which one is going to be the more effective or the better option.
And not knowing a lot about this, if you take the second option and you're before the magistrate and you plead guilty or you get found guilty of breaching the offence, are we talking civil jurisdiction penalties? We're not talking a criminal offence, are we? Or?
It's what we might call quasi-criminal. It is technically criminal. If you are to go to trial, the criminal procedure rules all apply. It's a bit of an unusual one. Obviously, the police aren't going to enforce that. You're not sort of, you actually could be arrested, funnily enough, if you don't show up to court. The court can issue warrants if you don't appear when you've been ordered to appear, but it can go on your record.
So some pretty substantial penalties.
Yeah. I mean, typically the expectations have to be set quite realistically because if you've breached, say, a parking bylaw and you're before a magistrate, they might give you a small fine or they might give you a good behaviour order, which is probably what we would be asking for most of the time because obviously we just want it to stop. We don't really get a direct benefit from the fine because that just goes to the government. We would prefer that the breach stops. I mean, that's the end goal that we're trying to achieve. But if you're talking about sort of down the track, maybe you've got an adjudicator's order and they're not complying with that order, the fines are very severe. I think it's something like $30,000 is the maximum fine. I'm not sure exactly off the top of my head, but it's a lot larger than the fines that you would get from just going down the contravention notice route. But obviously, as I said before, it's a much longer process. And the actual end result of all of it is, and there are cases where this has happened, and it can be something as simple as you're feeding birds on the common property and they get the contravention notice, they keep doing it. They get an adjudicator's order to stop and they keep doing it. Eventually, if it gets to a point where it's so severe, you can register the adjudicator's order in the Magistrates Court. It then becomes an order of the court. And if that person doesn't comply with that order, they're in contempt. And that is an offence which can see prison time. It can see all the sort of more severe, I think it's 2 or 3 years anyway, maximum sentence, a custodial sentence. And people don't sort of think of it in those terms when you're looking at a breach of a bylaw. But if it continues on, and that's something that would take years, but if it continues on and it's causing issues, eventually that is an option. So it's quite a process, and the options continue in escalation for quite a while.
So for those of you who, like me, maybe thought these bylaws were just getting a slap on the wrist for non-compliance, I think what Alex has told us today is that it's far more substantial than that. And these body corporates are absolutely entitled to enforce the bylaws which have been validly approved.
Yeah, if they've been if they're valid and if they've been validly approved, and that's something I think Juliet might have spoken about it in a previous podcast. But a lot of bylaws aren't necessarily valid. Just because they're in the CMS, the Community Management Statement, doesn't necessarily mean they're valid, and that's sort of one of the first things that we'd look at if we're acting for a body corporate.
So if you're in a body corporate and you've got other occupiers not complying with their bylaws and you want to seek enforcement, contact Alex or our body corporate team here at OMB for an assessment of the validity of the bylaws and a discussion of enforcement options available to you, because by the sounds of it, there's definitely a lot. Alex, thanks for coming in today and explaining what I think is a really interesting area of body corporate and strata law.
Thanks, Simon.
And stay tuned for the next episode of the OMB Law Board.